Hello everyone and welcome to Vakilaw, Know the Law. I am Shivani and in today's session we are discussing about the subject the Indian Contract Act of 1872. In my previous session, I have discussed about the concept of mercantile law, the Indian Contract Act of 1872, concept of contract. I've also shared a brief history of the Contract Acts of India and I've also taken an overview of the Indian Contract Act of 1872. I have mentioned the link of my previous video in the description box. So if you've missed it, do check out in the description box below. So now we are moving on to the next part in today's session. So today we will be taking a look at the arrangement of sections of the Indian Contract Act of 1872 and we'll also take a look at the salient features of the Indian Contract Act 1872. So let's begin with the arrangement of sections. So the first part is the preliminary part, which includes the short title, extent, commencement and interpretation clause, etc. Chapter 1 of the Indian Contract Act deals with communication, acceptance and revocation of proposals, which has been provided under sections 3 to 9 of the Act. Chapter 2 deals with contracts, voidable contracts and voidable agreements, which has been provided under sections 10 to 30 of the Act. Chapter 3 deals with contingent contracts, which have been provided under sections 31 to 36 of the Act. Chapter 4 deals with performance of contracts provided under section 37 to 67 of the Act. Chapter 5 deals with certain relations resembling those created by contracts, which have been provided under sections 68 to 72 of the Act. Chapter 6 deals with the consequences of breach of contract, which have been provided under sections 73 to 75 of the Act. Chapter 7 of the Act deals with sales of goods, section 76 to 123. These sections have been repealed. Chapter 8 of the Act deals with indemnity and guarantee, which have been enumerated in sections 124 to 147 of the Act. Chapter 9 deals with bailment, which have been provided under sections 148 to 181 of the Act. Chapter 10 deals with agency, provided under sections 182 to 238. And Chapter 11 relates with partnership under section 239 to 266. These sections have been repealed. Also, a schedule was included in the Indian Contract Act of 1872, which has been repealed. Okay, so now moving forward, we will now be discussing about the salient features of the Indian Contract Act of 1872. So the main feature is about the arrangement of sections that I have discussed earlier. So this arrangement also is a very beautiful feature of the Indian Contract Act of 1872. It's that it covers all provisions and all sections that are related to contracts, rules, provisions, elements, essentials, types of contract. Everything has been covered under all these sections. So this is the main basic feature of the Indian Contract Act of 1872. Also, in my previous video, I have discussed about a very main and major feature of the Indian Contract Act. Now listen to this feature once again very carefully. It's that the Indian Contract Act of 1872 is the only law in India that has been formed which covers everything about the law of contracts. Also, it is the only law which deals with the general principles of contract. I also discussed that the Indian Contract Act has been formulated in two parts. The first part deals with the general principles which have been mentioned in section 1 to 75 of the Act. And the second part deals with specific kinds of contracts which are of indemnity, guarantee, bailment, pledge and agency. So we'll be dealing with all these sections in the later sessions. But this also is a main feature of the Indian Contract Act, that it mainly deals with the general principles of the law of contracts. Also, it specifies specific contracts like indemnity, guarantee, bailment, pledge and agencies, and provisions regarding the same have also been enumerated under the Act. Now we will further move towards advanced features of the Indian Contract Act. So basically, the Indian Contract Act of 1872 defines the term contract under section 2H of the Act. It thus states that a contract is an agreement that is enforceable by law. So the key words of this definition are that basically a contract is an agreement, and such contract or such agreement is enforceable by law. So if you want to draw a mathematical formula for this definition, you can say that agreement plus enforceability by law is equal to a contract. Okay, so a contract is an agreement, the object of which is to create a legal obligation. Anson has defined the word contract as: the law of contract is that branch of law which determines the circumstances in which a promise shall be legally binding on the person making it. The Indian Contract Act of 1872 also provides for acceptance of proposal, its essentials, how acceptance is made, communication of proposal when complete, communication of acceptance when complete, communication of revocation when complete, revocation, when a proposal or acceptance can be revoked, how a proposal can be revoked, and so on. The Indian Contract Act 1872 provides for valid contracts under section 10 of the Act. The section states that all agreements are contracts if they are made by the free consent of the parties competent to contract for a lawful consideration and a lawful object, and are not expressly declared to be void. The section further provides that if a contract has to be in writing under the provision of any other law, then it must be in writing. For instance, if there are memorandum and articles of association or company, if there are any mortgage deeds or any trust deed or agreements for transfer of property or sale deeds, all such agreements are required to be in writing under the respective laws. So if there is such a condition, then it is essential that such contracts are required to be in writing. Further, the Indian Contract Act also provides for competency of parties to a contract, which has been stated under sections 11 and 12 of the Act. Section 11 of the Indian Contract Act of 1872 lays down that a party is competent to contract if he is of the age of majority, he is of a sound mind, he is not disqualified from contracting by any law to which he is subject. It also lays down provisions which are relating to minors' agreement, contracts by lunatics, drunkards, married women, persons of unsound mind, and contracts by governments or corporations, etc. The Indian Contract Act of 1872 also lays down provisions which are related to consent and free consent, which is an essential ingredient of a valid contract. So consent and free consent are the two major ingredients of a valid contract, of which the Indian Contract Act provides for. Under section 13 of the Indian Contract Act, it is said that two or more persons are said to be in consent when they agree upon the same thing in the same sense, that is consensus ad idem. Under this head, there are important provisions regarding coercion, undue influence, fraud, misrepresentation and mistake. Mistake consists of mistake of law and mistake of fact, and also provides for remedies for mistake. The Indian Contract Act of 1872 also lays down important aspects of contract, that is, provisions for lawful consideration and lawful object. It has been covered under sections 23, 24, 57 and 58 of the Indian Contract Act of 1872. The Indian Contract Act also provides for when consideration or object of an agreement is lawful and the acts that are forbidden by law in this regard. Also, the Act provides for agreements without consideration. This has been provided under section 25 of the Act. Thus, section 25 provides that an agreement made without consideration is a void agreement except in 3 cases. So, there are exceptions that has been provided under the Act, which are: the first exception is natural love and affection, which has been stated under section 25 subsection 1. Exception 2 is promise to compensate for voluntary services, which has been provided under section 25 subsection 2. And third exception, promise to pay time barred debts, which has been provided under section 25 subsection 3. Further, sections 26 to section 30 of the Contract Act declares the following agreements to be void. First, agreements in restraint of marriage, agreements in restraint of trade, agreements in restraint of legal proceedings, agreements which are uncertain, and agreements by way of wager. The Indian Contract Act also provides for contingent contracts, which have been stated under section 31 to 36 of the Act. So, it defines the term contingent contract as a contract to do or not to do something if some event which is collateral to such contract does or does not happen. The Act also further provides for rules relating to contingent contracts. Further, Chapter 4, Sections 37 to 67 of the Act deals with various rules as to performance of contracts. It provides the obligation of parties to perform contracts under sections 37 to 39. It provides by whom contract must be performed under sections 40 to 45. It provides for time, place and manner of performance under sections 46 to 50 and section 55, and also for performance of reciprocal promises, which has been provided under sections 2, 51 to 54 and 57 of the Act. It also provides for performance of alternative promises under section 58. It also provides for rules as to appropriation of payments under sections 59 to 61. It provides for modes of discharge of contracts under sections 37 to 39, 56, 62 to 64 and 67 of the Act. And the Indian Contract Act deals with quasi-contracts under sections 68 to 73. It provides for all 5 types of quasi-contracts. Chapter 5 of the Indian Contract Act deals with certain relations resembling those which are created by contracts, which are also known as quasi-contracts, which have been provided under section 68 to 72. Here 5 types of quasi-contracts are being provided for, which are: section 68 deals with supply of necessaries, 69 payment by interested person, section 70 liability of payment for non-gracious act, gracious astadi. Section 70 provides for liability of payment for non-gracious act. Section 71 deals with finder of goods and section 72 for mistake or coercion. Further, sections 73 to 75 of the Act deal with breach of contracts. These sections provide for rules of measure of damages, compensation for breach of contract, right to rescind and quantum merit. Further, the Indian Contract Act of 1872 also deals with specific kinds of contract, which are indemnity and guarantee under Chapter 8, sections 124 to 147, contracts of bailment under Chapter 9, which are under sections 148 to 181, and contracts of agency under Chapter 10 dealt under sections 182 to 238. Okay, so now we've understood about the salient features. I've also discussed about the arrangement of sections, and in my previous video I've also discussed about a backdrop, history and an overview of the Indian Contract Act. So for prepping up for your exam, you may face a long question regarding the salient features and overall history of the Indian Contract Act. So what questions can you face in the exams as a long question as well as for short notes, and how can you write your answers is the part I'm going to discuss in the upcoming sessions. So please don't miss my next video, my next session relating to the Indian Contract Act. That's all for today. I hope you are satisfied with my information. So see you in the next video. Till then, stay tuned to vakilaw, know the law. Also, don't forget to like, share my videos, and also please remember to subscribe to my channel vakilaw and hit the bell icon for any updates of videos on my channel. Till then, this is me Shivani signing off. Stay tuned to vakilaw, know the law. Bye bye.